Good evening, everyone, and welcome to the BicTok, the session 34, titled Navigating the JKR Sarawak Forms of Contract. My name is Michelle, and I'll be your host for today's session. And thank you for joining us this evening. And before we begin, let me run through a few housekeeping matters. Firstly, kindly ensure that your Zoom username reflects the name under which you registered. This will allow us to accurately mark your attendance and where applicable, issue your certificate of participation and CPD points. Secondly, if you have any questions during the session, please feel free to leave them in the chat box. Alternatively, you may also raise your questions during the Q&A session at the end. To guide today's session, we are honored to have with us our moderator, Surveyor Isabel Sim Tseu Yu. Surveyor Isabel is a Senior Principal Assistant Director at the Public Works Department Sarawak headquarters. With extensive experience in contract administration, procurement, and policy development, she has been instrumental in the implementation of major public sector projects across Sarawak. She also serves as an advisor to the Special Task Force behind the JKR Sarawak General Conditions of Contract PWD 75, the 2021 version, amongst others key initiatives shaping Sarawak's infrastructure landscape. We are truly privileged to have her moderating today's session. So without further ado, please join me in welcoming Isabel Sim.
Thank you so much, Michelle, for the incredibly kind introduction. Once again, welcome everyone to this evening's BicTok session on navigating the JKR Sarawak forms of contract. As the moderator for this session, I'm absolutely delighted to introduce our two very distinguished and learned panelists, both of whom I have had the wonderful privilege and opportunity of having worked with in the local Sarawak built milieu. They are authorities in their own right and key drivers in their fraternity, as well as the local built environment, where they have led numerous initiatives to create revolutionary paradigm shifts in the Sarawak construction scene. As I am sure you have already gathered from their impressive biodatas, allow me first to introduce Surveyor Richard Fu, who is the Managing Director of FCH Quantity Surveyors Sdn Bhd, a local QS consultancy firm with over 35 years of experience. He is a registered consulting quantity surveyor with the Board of Quantity Surveyors Malaysia. He is also a fellow of the Royal Institution of Surveyors Malaysia and a past chairman of its Sarawak branch. On top of that, Surveyor Richard is an associate member of the Australian Institute of Building and currently sits as a board member in the Board of Quantity Surveyors Malaysia. We are also graced by the presence of technologist Jocelyn Yeo, who is currently the Principal Assistant Director in Public Works Department, Sarawak. She is heading the Contract Services and Legal section and is a subject matter expert, having dual qualifications in quantity surveying as well as law. She acts as Secretariat for the Sarawak Contract Coordination Panel and the PWD Claims and Appeal Committee. Technologist Jocelyn is also part of the task force that drafted the PWD 75 version 2021, which will be our topic for discussion today, and is currently in the midst of drafting several other key Sarawak forms for the purpose of effective contract administration. Thus, based on their illustrious careers, coupled with their wealth of knowledge and experience, we will be getting them to share from their respective vantage points and perspectives on the new JKR Sarawak General Conditions of Contract, PWD 75 version 2021, as compared to the previous JKR Sarawak form of contract, PWD 75 version 2006. Hence, without further ado, it is my pleasure to hand over the session first to Jocelyn, who will start by giving us the general rundown and comparisons between the two forms to give our audience the heads up and a better grasp of the differences made before we get Richard and Jocelyn to share with us their views regarding this new form. So over to you, Jocelyn, please.
All right, thank you, Isabel. Let me share my screen. Good evening, everyone. I'm glad to be here and to have this opportunity to speak at this BicTok session regarding our JKR Sarawak conditions of contracts. I'd like to thank the organizer for the kind invitation to share our thoughts and experiences on this. So let me begin with maybe let me share a little bit of our history regarding this. Like some of us might know, the GKR Sarawak forms of contract have long served as the backbone of how we administer and manage public works projects in the state. Over the years, they have evolved, shaped by the lesson learned, feedback from the industry, and our continuous drive to ensure greater clarity, accountability, and efficiency. So this session gives us a chance to reflect on how these forms function in practice, the principles behind them, the challenges we often face on the ground, and how JKR Sarawak has been continuously improving our frameworks to align with the current realities and the industrial standards. So before delving into the current version, allow me to briefly touch on its predecessor, which is the JKR Sarawak form of contract, PWD 75 version 2006. This version was actually launched back in 2007 and has remained unchanged since then. So in view of the recent developments, including new legislations like circulars and the evolving tata cara perolehan negeri, so it became necessary to review and update the 2006 version. At that time, the intention was clear. We are to ensure that the contract documents remains relevant, practical, and aligned with the current needs of the construction industry, while promoting efficient and effective contract administration. This is vital to support the government's aspiration to deliver projects that meet both the expectations and well-being of the rakyat. So the revamp and review exercise was also part of the Sarawak Civil Service SCS 1020 action plan, which aimed at propelling state service delivery to a world-class standard. That time, the main objectives of this review actually were to enhance project delivery through improved provisions on time, cost, quality, as well as safety, and enable employer intervention through assignment in cases of projects delay, and to provide alternative remedies to address non-performance without resorting to determination, and to synchronize with the latest legislation, reflect current administrative processes, strengthen checks and balance in contract administration, clarify the duties and obligations of the contracting parties, and as well as to reinforce the rights and interests of the parties involved. The updated JKR Sarawak General Conditions of Contract, the version 2021, specifically addresses several key areas, which are the contractor's obligation to comply with safety requirements, management of work delays, mechanism for dispute resolution prior to litigation, security for design responsibility, provision for change in circumstances affecting site possession, and to expedite payment procedures pursuant to SIPA Act. So this version 2021 now contains of 5 parts and 53 clauses as compared to the version 2006, which only have about 24 clauses. And from here we can see actually 2 clauses, which are the clause 38, which is the retention money, and clause 48, fluctuation of price, have been deleted, while several new subclauses have been incorporated. So actually, due to time constraint, I will only focus on the newly added clauses and their significance. Like, I won't go through every single clauses here. So clause 4.2.1 and clause 4.2.2 are new subclauses that have been added to incorporate for contract based on different nature. The mutual explanatory and parity of documents effect of this clause is to actually assist the interpretation of the contract documents. However, in the 2006 version, this provision actually was not clearly stipulated on whether the contract is formed based on drawings and specifications or bills of quantities. So here, as you can see, for lump sum contract, we just want to stress on the fact that drawings and specification will take precedence over the summary of tender, whereby those contracts on BQ, the bills of quantities will take precedence over everything else. So of course, like all the documents are mutually explanatory, but it's just that in case of any ambiguity and discrepancies, then this clause has included specifically which documents to take precedence if there are any inconsistencies arising between the documents. So next is regarding the clause 6.5, which is the safety and health at site. At that time, why we decided to include and incorporate this clause in the 2021 version was because safety is actually such a critical thing that it involves loss of lives. The provision on safety and health requirements, as well as the contractor's obligation pertaining to safety at site, were not comprehensive nor explicitly specified in the 2006 version. So over the years, we have a lot of like incidences which actually contribute to death and major accident on site, which we feel that it can be avoided or eradicated. So this is something that is not inevitable, but something that is preventable. So that's why we want to institute all these clauses to ensure that safety is in place with utmost importance on site. So this new subclause, which is clause 6.5 here regarding safety and health at site, has been added and developed. And this new subclause has been inserted under clause 6, general obligations of the contractor, where this subclause explicitly defines safety requirements, where the contractor, his personnel, workmen, and subcontractors are required to understand, comply, and perform their obligation, especially with regards to safety requirements in the contract and the law related to safety at site, like for example, the OSHA. So in this new subclause, submission of as planned by the contractor to the SO is required before execution of works on site. So next, under this performance security, under clause 10, which is we have included to actually decided to follow the federal procedure. So where the provisions of cash deposit was deleted, as actually it's no longer applicable here. Initially, for a lot of the stat contract, why we actually at that time had that cash deposit, because I think when the FOC was drafted back then in 2006, the magnitude of our project were not as large as compared to the mega projects that we have today under the state. So the contractor can actually come up front with the 5% cash of their contract sum. But this is actually no longer possible and no longer practical, as we can see the projects that we are implementing now today are of a bigger magnitude. So it is actually quite impossible in a sense for the contractor to come up with the 5% cash of the contract sum as an option that shall be deducted if a bond with a licensed bank or financial institution is not opted by the contractor. So this is to relieve the contractor's financial burden by replacing the cash deposit with continuing guarantee sum, as cash flow is very important to the contractor. And also the 2021 version has an added provision under the clause 10.5 for the forfeiture of performance security, where the employer actually has the right to forfeit the performance security if the employment of the contractor is determined. As earlier on, there were actually a lot of questions raised by our contractors that why their performance security were forfeited after determination, and why is the employer allowed to forfeit the performance security. Actually, it's not stated anywhere in the in our contract, the 2006 version. But actually, this was stated clearly in the bank guarantee, but unfortunately, it's not in the FOC, the 2006 version itself. So to eliminate any ambiguity, we decided might as well we insert this into this 2021 version. So next is regarding the employer's right to intervene. So in the 2006 version, there is only one option to cater for sick project. For example, the determination of the contractor's employment. I think we all know that with determination of contract, there are actually high costs involved. So at that point in time, when we were drafting this, we were actually thinking of how to minimize costs if, let's say, we had no choice and if the contractor is critically delayed. So this is actually an option in lieu of determination of their employment under the contract, which is to give us the right to intervene, but notwithstanding, even though we have the right to intervene, when it comes to assignment, we must have the contractor's consent first before we can actually ask them to assign the contract or part of the works to the another contractor. So to be in line with the that strategic intent to have a zero sick project, the new subclause 23.5, as you can see here, allows the employer to intervene by assigning part of the work to be approved to the approved subcontractors with contractors' consent in writing. However, in this case, the percentage of the delay will be determined by the employer, and this shall be stated in the appendix to the general conditions of contract. So the discretion has been given to the agency on how much they actually want to put in before you can come in and intervene. So this is to enable that so-called like a rescue option is provided instead of determining the contractor's employment under the contract. So with this, we believe that a shorter time shall be taken to complete the delay works instead of procuring a new contractor to complete the works. A new subclause regarding this design guarantee bond is also added to the 2021 version. So clause 30.4 requires the contractor to provide a design guarantee bond for any portion of design undertaken by himself. So actually, this is this particular clause is actually to address proprietary items, like meaning certain items that maybe something like the roof truss that are actually supplied by the service provider, and the design is actually from them. The design guarantee bond acts as a security for the contractor's obligations and warranties, actually amounting to 5% of the value of the design works, and shall be valid for a period of 5 years and 6 months from the date of the CPC. So in the event of any defects or damage occurring on that particular part of the works due to design deficiency, the design guarantee bond shall be demanded, limited to 5% of the value of the said works. So the government has the right to claim from the PB and the sum equal to 5% of the value of the works. So the contractor shall provide or top up additional design guarantee bond for any amount not less than the amount demanded by the employer as stipulated here in clause 30.4b. And also, if the contractor is also required to extend the security if the design guarantee bond were to expire. This clause is to adopt the current practice in construction industry to provide a security for the design which was previously silent under the 2006 version. A new subclause regarding the correcting error or discrepancies in interim payment has also been added here. So it is clearly stated that the SO is now made by a subsequent interim certificate, make correction or modification is in respect of any valuation errors in any earlier interim certificate. So this clause is just to allow the SO to be able to correct or make amendments or reconcile the figures in the subsequent interim payment certificate, which this was not mentioned in the 2006 version as well. So in order to make things clear, practical completion is clearly defined in this subclause, which this was not defined under the 2006 version. So works can only be certified as practically completed when the following conditions, as stated here, have been met. All works are completed in accordance with the contract, must be fit for use as their intended purpose. Works have passed all necessary T&C and other requirements stated in the contract as a prerequisite for the issuance of the certificate of practical completion have been complied with. Yeah, this is regarding the mediation clauses. So previously in the 2006 version, this arbitration was in the 2006 version, but not mediation. So one of the most progressive inclusion of this is regarding the reference to mediation as an alternative method of dispute resolution. So under the 2006 version, dispute that could not be resolved amicably were referred either to arbitration or litigation. However, after consultation with our Sarawak State Attorney General's chambers, it was agreed that the arbitration clause is to be removed. And this decision was made primarily to address concerns relating to the time and cost, as arbitration actually less formal than court proceeding still tends to be protracted and costly in practice in a sense. So that is why we include this mediation clause, which offers a more practical and collaborative approach. So it is actually less formal, more flexible, and allow parties to resolve disputes efficiently and amicably without the rigidity of legal procedures. So it also promotes open dialogue, preserve working relationship, and results in shorter resolution times with significant cost savings, I can say. So under this clause, a mutually agreed mediator may be appointed by the parties, and any issues resolved or terms agreed upon shall be recorded through a supplemental agreement. In the 2006 version, the provision for suspension of work actually is not comprehensive and not explicitly spelled out, including the SOs and the contractors' roles, especially during the suspension period. So the contractual implications and repercussions and the resumption of works after the lifting of suspension. So this new subclause, which is clause 43 of the general conditions of contract, this suspension of work has been added. So it explicitly stipulates the options and actions available to the SO when dealing with issues or delay due to acts of prevention by the employer. The GCC also expressly states that the contractor's obligations for works not affected by the suspension. This clause provides options to the contractor to either mutually terminate or agree to stand by and be suspended for a further period of time in the event of suspension continues for more than 12 months. So with this, the contractor is actually not entitled to claim for any loss and expense, and the delay percentage will not be further affected. Thus, won't be considered as a critically delayed projects over and above. The contractor will also not be imposed LNAD here. Actually, this is also to cater for a change of circumstances at site on the ground that makes continuing with the works impossible in short term. Like, for example, sudden blockades of the site after possession. Something to do with utilities issue as well. Since the issuance of these 2021 version, 3 addendums have actually been released to further refine and clarify the certain specific provisions. So here, as you can see, along with both versions of the contracts available for download from our official website as shown here. Okay, and that brings me to the end of my sharing. And thank you.
Thank you so much, Jocelyn, for the truly explicit comparisons made. I would just like to highlight further to our audience that for all intents and purposes, the new JKR Sarawak General Conditions of Contract, PWD 75 version 2021, is tailor-made to suit the implementation of projects solely under the purview of Sarawak, having considered the local prevailing policies and statutory requirements, as well as the underscored interests of all our stakeholders. So let's now move on to the pinnacle of our session to hear distinctively from our panelists their views on the PWD 75 version 2021. So why don't we start with Surveyor Richard? From your experience, Richard, how does the JKR Sarawak form compare with other standard forms like FIDIC, PAM, or AIAC in terms of risk allocation and fairness?
Thank you, Isabel. Yeah, I think first of all, as is expected, not just of the JKR Sarawak form, but with other similar forms, government or client-based contract forms, the JKR form does not allow as much leeway as many of the other forms, for example, PAM, AIAC, FIDIC, etc. I think we also understand that even within the non-government or non-client forms of contract, there are various states of, if you like, balance between looking after the rights of the employer and the contractor. I think Jocelyn has already mentioned, and you as well, Isabel, just a few moments ago, that we need to take cognizance of the fact that the JKR Sarawak form is, it takes into account the protection of the state government's interests, JKR's interests, and it is also designed to take cognizance again of internal processes, safeguards, contract governance, and even things like how the state government looks at or intends to manage the risks between the parties involved. Having said that, I mean, there are areas, for example, even straightforward areas. If we look at EOTs, for example, if we compare against PAM contract, of course, the PAM contract has a number of, a lot more, I suppose, relevant events that would entitle the contractor to claim extensions of time. Just a case in point would be, suspension of work by the contractor, for example. Of course, that is silent within the JKR Sarawak form of contract. But having said that, again, I think that's a broad overview of how I view the difference between the JKR form and the other forms at large out there. But one of the things, these are not one of the main clauses, but I think it's also worthwhile to highlight that the JKR Sarawak form now has this termination of contract based on state interest, which is very much similar to what has been in the federal JKR 203 form, where the employer, can the contract allows the employer to terminate the contract without any obligation to give any reason for the decision. And the definition of the state interest, policy or security is to be made solely by the employer. Another area, quite a minor area, but I think it's dearly loved by a lot of the practitioners locally, is the prescriptive nature of the clause for extension of time arising from exceptionally inclement weather. I think now we've got that provision where we talk about a methodology for working out the number of unworkable days, thus leading to the quantum of delay that the contractor is entitled to. And I must say that this was quite easy for most practitioners, I think, to accept and to follow, because it basically takes into account what I believe has been used by many practitioners here, at least in Sarawak, over the last few decades, how EOT has been calculated, in the earlier forms of the PWD contract, I think going back as far as to the 1969 form. Yeah. Okay.
Thank you, Richard, for the truly honest opinions. I must admit, we do acknowledge the grouses from the certain affected quarters in the industry, especially on elements of partiality. But again, I wish to reiterate the fact that the interests of our stakeholders have to be upheld first and foremost. But notwithstanding, the Sarawak government has actually introduced a lot of other initiatives unique to Sarawak itself to address as well as to assist our local industry players, where we have really taken into account the welfare of the local consultants as well as contractors, which we will elaborate on a separate platform. So moving on, Jocelyn, we understand that the JKR Sarawak form of contract has been progressively developed over the years. What are the main objectives behind developing Sarawak's own form instead of adopting standard ones like FIDIC, PAM, or PWD Malaysia forms?
The JKR Sarawak form of contract actually was conceived out of necessity, I can say, driven by the Sarawak's distinctive administrative procedures, statutory environment, and project delivery landscape. So while the federal PWD form and the other standard documents like PAM or the AIAC even offer sound foundations, but they were actually not fully responsive to the challenges we face actually in Sarawak, like be it in the geographical spread, the nature of our projects, or the statutory autonomy we exercise under the MA 63. So our projects often span vast and remote areas involving multiple stakeholders across divisions. And actually this requires a form that offers clarity, practicality, and flexibility suited to our local conditions. I can say one of the main objectives was to ensure that contractual provisions are in harmony with the Sarawak's procurement governance, which is distinct from the federal systems. For example, our state treasury instructions and financial authority delegations, approval procedures, payment flows, and contract management mechanism differ slightly from those applied in federal agencies. So by developing our own form, JKR Sarawak ensures that internal consistencies across all project stages, like from tender to completion, without constantly having to adapt or amend national templates. Another important consideration is the ability to address lesson learned from our own experiences. Like over the years, issue like variations, delays in approvals, and contractual ambiguities have been recurring themes in infrastructure projects, such as like you can see here, the coastal roads and the second traveling roads as well. So these projects have given us integrates this valuable insight into what works and what actually doesn't. So the JKR Sarawak conditions of contract integrates these lessons, embedding provisions that clarifies the roles, tighten notice requirements, and establish a stronger administrative backbone for contract implementation, I can say. So it actually also represents an evolution of our institutional knowledge, like when we talk about ownership of a form. It actually is not just about the authorship, but actually about the accountability and adaptability. So JKR Sarawak actually can refine, amend, and issue circulars to improve clauses without waiting for the federal revisions, like approval from them. Actually, it sometimes takes a little bit of time here. So this flexibility has allowed us to develop specialized versions, like which upcoming, hopefully, like we are still developing for several more conditions of contract. So maybe I can say like our goal actually is to balance the legal robustness with operational practicality. We wanted a document that be it with like the engineers, the QSs, or the site personnel could actually use and interpret. So the language, though formal, is grounded in the realities of project administration, and it serves to protect both the government and the contractors in a sense, ensuring transparency and accountability while promoting fair dealings. So yeah, JKR Sarawak form of contracts actually is a living document born out of Sarawak's unique administrative context, shaped by our practical experience and continuous evolving to meet the modern construction demands.
Wonderful. I echo Jocelyn's sentiments. I wish to recapitulate the fact that Sarawak is highly unique in terms of governance and the local construction landscape. Thus, the pressing need to cater to the risks which we have identified accordingly, especially pertaining to the projects under the purview of the Sarawak government. Here, I must admit that over the years, we have fought for the devolution of power and the corresponding autonomy that comes with it. So Richard, in practice, what do you think are the most frequent challenges consultants encounter when administering projects using the JKR Sarawak form?
Okay, yeah. Not trying to point fingers here, but but one of the first areas I think that many contracts experience. I think this arises because the range of contracts under JKR Sarawak, they can go from the mega projects, infrastructure projects, to small school projects, etc. So you get a very wide range of contractors, and with that comes contractors of very varying ability in their understanding of the contract, and also in their discipline in terms of how they do the contract administration. I think one of the main areas, problematic areas here, are compliance with the notice precedents. The various notices that you've got to put up in claims, whether it's a cost claim, loss and expense, an extension of time, etc. So I think basically this arises from a lack of knowledge about the contract provisions, or a lack of familiarity, maybe not so much knowledge. It can be from a weak contract administration, and then some real problems on the ground is because some of the timelines can be quite tight. And so obviously, you've got to look at what is happening on site, and in many instances, it's quite difficult to stick to the timelines. So I suppose what I'm trying to get here is that when that happens, then the contract administration as a whole becomes a lot more messy, and that becomes, a challenge for consultants generally. The other area, but again, this is administrative, and I'm not sure. I don't have a solution as to how this can be mitigated or avoided. The approval procedures, for work changes, that can become quite protracted. But I think I must admit that this is not a failing of the JKR Sarawak contract as such. It is something that a lot of people experience, a lot of contract administrators experience. Again, as I said, because of the range of and the types of projects that come under JKR Sarawak's purview. I think one of the other challenges is expectations of the parties. Obviously, the consultants or the SO, their remit, if you like, is to administer the contract as closely as possible, or strictly in accordance with the provisions or the conditions of contract. But there are other parties involved. Expectations from the contractors may be different. So especially, when it comes to money, you're talking about payments or valuations or variations, etc. There can be quite, different expectations arising possibly from different interpretations of the provisions of the contract. So I would say, that's basically sums up, the main challenges that we quite often experience.
Okay, thank you, Richard. But going back to what you were saying just then, I believe you do know that PWD Sarawak is constantly trying to engage with consultants, and we've been having we've been conducting various engagement sessions, and we're also trying to understand as well as to bridge whatever divide that exists in the hope of maintaining public sector project delivery excellence so as to align to the vision and of a sustainable and prosperous Sarawak. And going back to the issue of, I think, the time taken for approvals and all that, I think it's a well-known fact that for public sector projects, we are governed by a lot of prevailing policies, circulars. So it's basically procedural, which we cannot do away with.
Yes, I think that is
public
well
sector
understood.
projects.
Yeah, that is well understood. But I think where, from the consultant's point of view is that in order not to exacerbate the problem, whatever is within the purview of the consultants, whatever, potential delays that may come from, interactions with what is actually happening on site, those are areas where the consultants can help. Taking into consideration all these procedures that need to be to happen, that the consultants, I suppose, need also to play their part to try to mitigate the long process. Yeah.
Having said that, I think you also know that we are also constantly trying to come up with new initiatives to try and improve our processes and all that. So I think in the last few years, we have managed to actually introduce quite a number of new initiatives that have made a great impact to the way we administer our projects in Sarawak. Yeah.
Yes, that's right. Yeah.
All right. So we'll move on to question 2 for Jocelyn. So what do you think are some of the most common contractual issues or misunderstandings faced by project teams when using the JKR Sarawak form?
I think one of the recurring challenges in contract administration, even with a well-structured form like our forms of the conditions of contract, is the gap between what the contract requires and how it is actually applied on the ground. Like, despite the clarity of provisions, many project teams still face issues stemming from procedural non-compliance, like poor documentation, I can say, or misinterpretations of the roles here. A very common misunderstanding relates to the submissions of the EOT notices and claims, for example. Contractors sometimes treat the EOT procedures as a mere formality, submitting notices late or without any sufficient supporting documents. So under the conditions of contract, the notice requirement, like what Surveyor Richard have just now mentioned, actually the notice requirement is not optional, but it is like essential procedural safeguard that protects both parties. So yet actually in practice, some site teams view that this as an administrative bureaucracy rather than a contractual necessity. So this often leads to dispute when delays occurs, like and contractor later seek time extension of time that cannot be properly justified here. So for instance, in several packages under some of our projects, like we observed that delays caused by prolonged rainfall and flooding could have been maybe accepted as excusable delays, but the contractors failed to issue timely notices, resulting in partial rejection of their EOT claims. And another common issue concern here, I think it's about the variation orders. So despite the clear stipulation that variation must be instructed in writing by the SO, site level personnel, especially in the remote projects, sometimes proceed with additional works based on verbal instructions or informal communications, such as like WhatsApp messages. So this practice creates unnecessary confusion during valuation. So as the formal chain of instruction becomes unclear. So in some of the, I can say like the rural school upgrading projects, for example, contractors have carried out like additional works for, let's say, the drainage and the access improvements based on a verbal site instruction. So when the matter reached their final account, the lack of written instruction complicated the verification, delaying payment and prompting claims dispute. So as we all know, like for government projects, we have a lot of procedural rules and regulations that we need to follow. So for example, the most common thing is like after CPC, there shall be no more DO rest. But a lot of the ongoing projects, actually, we are still facing these problems, and we have to, like if for federal projects, we need to write all the way to the federal to seek permission. So this will drag for quite some time. And also there is also like frequent misunderstandings of like roles and powers, especially between the SO and the SO rep. So SO typically that the project's can I say professional officer holds the authority to issue contractual directions like certified payments and assess plan. However, when the SO delegates site supervision duties, some contractors like mistakenly assume that the representatives' verbal directions carry the same binding effect. So this misperceptions has caused problems in projects in some I can say some of our projects where discrepancies between the SO formal instructions and on-site interpretation created like confusion over the scope and responsibilities. So one more thing is that regarding record keeping, yeah, we can see like although the contract stresses contemporaneous records like such as site diaries, correspondences, photographs, and progress reports, many contractors actually still neglect proper documentation. So when disputes arise, the absence of solid evidence weakens their position, even in cases where the underlying claims may be legitimate. So this is particularly true for projects located in some of the rural areas also, like making it challenging to maintain consistent documentation practices, like even for some of our own officers as well. Like what we always emphasize, documentation actually is very important. And finally, I think there is often also a gap in understanding regarding procedural interdependencies. So how clauses works together. Like for example, EOT provisions are linked to LNAD, and variation clauses interact with valuation and payment certification. A failure to grasp these interconnections can lead to procedural mistakes. So in summary, I think the most common issues are not inherent flaws in the form itself, but rather in its application, I can say. So the remedy lies in continuous education and training, not only for contractors, but actually also for our own officers as well. So by reinforcing understanding of procedures, emphasizing documentation disciplines, and encouraging consistent communication, actually we can minimize the misunderstanding and uphold the integrity of the conditions of contract, and as a fair and efficient instrument for project delivery, I can say.
Great, Jocelyn. Thank you for running through the entire gamut of issues with us just then. Richard, as a consultant, how do you manage or advise your clients when disputes arise under the JKR Sarawak form, especially before adjudication and arbitration?
Okay. Yeah, I think your question talks about, is asking about when disputes arise, but I suppose I would go one step back, one step earlier than that. In fact, one of the best ways is a preventive mindset. One of the best ways is to be prepared. So this is in itself is a practical and preventive approach that I believe probably involves two aspects. One is number one, the client team members, which includes the consultants, have got to get themselves familiar with the provisions of the form. I think there are many contracts, especially the smaller ones, where there will be team members who are not particularly familiar with the form and even the fundamental provisions in terms of issuing of instructions, approvals that are required before instructions can be sent out, things like that. And I think the second aspect of it is that having become more familiar, the project team needs to stay on top of or to stay in touch with the developments of the project construction. Because if you lose track of what's happening on site, you basically lose the opportunity to detect potential disputes at an early stage. So obviously, if you can detect disputes earlier on, then it allows for appropriate intervention, and then of course that allows you to avoid the dispute escalation. So how to do this? I think Jocelyn actually just mentioned it in the last few minutes. I would say that the parties, they need to engage early. They need to engage all the time. Good and contemporaneous records need to be kept, and these records need to be read, not kept and filed away. And no one knows what's happening, and then, minutes, correspondences, etc., they should be clear. They should capture the essential and material points rather than just be, filling in a form or writing a report for the sake of writing the report. And then, of course, in each particular project, you probably have procedures that are agreed within the project team. And then, of course, the contract provisions in the conditions of contract, these all need to be complied with. But I suppose in answer to your question, should disputes progress further, even with all these so-called preventive steps, negotiation, mediation, that should be employed as the next stage. I think it's good to note that the current JKR form of contract actually provides for mediation. If I'm not mistaken, not just a reference to mediation, but it's actually a precondition to litigation. And of course, the previous condition of contract, JKR form of contract, made no mention of mediation, if I'm not mistaken. But I think also, as explained by Jocelyn, the previous contract, I think, had references to arbitration, but that's now been taken out. And that's, after discussions with the Attorney General's office. So I think prior to any litigation, arbitration, I think the first steps will be, number one, prevention, and number two, if that does not work, then negotiations. Negotiations, I would say, even pre-mediation. The parties would just need to informally sit down and try to resolve the situation. I suppose basically practical aspects, those will be what we will adopt, when it comes to disputes or the potential of disputes coming in.
More non-adversarial approaches, in a sense.
Yes. Because the word non-adversarial, actually, that is very important, because I think it helps preserve relationships within the contract.
Absolutely.
And then also, generally, I think you'll be able to save a lot of costs and likely time as well.
And I think in Sarawak, because we're not that big, so it's very important for us to maintain relationships.
Exactly.
Even in terms of consultants and all that. It's like we basically only have like a handful of, for example, QS consultants.
Correct.
And I think you've been involved in a lot of our projects as well. So I think,
right.
Maintaining good relationships, that's of the utmost importance.
Yes. Yeah.
Okay. So thank you, Richard. Jocelyn, are there any current or future plans by JKR Sarawak to revise, refine, or further revamp the form, perhaps to include provisions for digital documentation, BEAM, or sustainability criteria?
I can say yes. Actually, JKR Sarawak is already moving towards modernizing its suite of contract forms to reflect new technologies like project delivery models and sustainability objectives. So our aim actually is to ensure that the contractual framework remains relevant and responsive to the evolving construction landscape. The department actually recognizes that construction is no longer purely about physical works. It is increasingly involves digital processes, integrated project management, and environmental accountability as well. like maybe some of us might know, our department actually just won the Family Award recently.
Yes.
Yeah. So in near terms, like one of our major focus maybe is to incorporation of the digital documentation and e-submission procedures. So many of our projects, particularly those under the schools redevelopment or even the coastal roads project, involve multiple consultants, divisions, and layers of approval. So physical paperwork has proven actually inefficient. Like we are now exploring provisions that allow for electronic correspondences, digital certifications of payments, and e-records as legally recognized documentations under the contract. So the intent is to align the contractual practice with Sarawak's broader digital government initiatives under the post-COVID development strategy, the PCDS 2030. And another key development is the gradual integration of building information modeling, the BIM. Well, I think BIM is not yet mandatory. Is not yet mandatory across all JKR Sarawak projects. But
It's
some
only for building
Yeah.
projects 10 million and above, and for infrastructure
Yeah.
projects 100 million and above. Yeah, those would
and
be mandatory.
yeah, so certain federal projects building managed by the state have demonstrated its value in clash detection, I can say, coordination and asset management. So the contract forms of the future will likely include clauses governing BIM responsibilities, like data ownerships and model accuracy, I can say, ensuring that digital collaboration is properly managed and disputes over information controls can be minimized. In terms of sustainability, we are also looking into including provisions that reflect Sarawak's green infrastructure agenda. So future revisions may address requirements for environmental responsible construction practices, maybe like such as waste management, use of eco-friendly materials, or energy efficiency standards. So this is also aligned with the Sarawak's vision to become a green economy leader under the PCDS 2030. Yeah, so JKR Sarawak will continue to review our contract and we will gather feedback from projects across the state as well. So we have actually internal mechanism where field officers and consultants can submit observations and suggestions based on the practical experiences. So in maybe I can say long term, we foresee developing a digital enabled contract management ecosystem where tendering, certification, and contract administration are integrated on a single online platform. Such a system would require the form of our general conditions of contract to explicitly recognize digital evidence, online submissions, and e-signatures as legally valid. So yeah, I think the refinement of conditions of contract is a continuous journey, and each revisions actually aims to enhance efficiency, fairness, and alignment with the Sarawak modernization goals. Yeah.
Great. Thank you, Jocelyn. How are we for time? Due to the time constraint, I think I will pose the final question to Richard before we open up to the audience for perhaps one or two questions. So, Richard, what improvements would you suggest to enhance the administration and usability of the JKR Sarawak form for both government and private key players?
Okay. I think in terms of suggestions to improve the form, what I would have in mind, I think Jocelyn actually has mentioned a few things. I think one of the ways that can help those administering the contract will be something like practice notes or user guide or manual. Such a tool, if you like, would, I think, serve a couple of purposes. One is that it should help greatly in fostering consistent practice. Where users lack some familiarity with the contract, then it acts as a reference tool, as to what to do under certain situations. So that is one of the things that I think can help improve the usability of the contract. Another area would be, I think, in our discussions over the past half hour or so, we have talked about, contract administrators or the contractors or the consultants maybe lacking knowledge or familiarity with the contract. So again, this is an area where constant and consistent training will be very, very helpful for clients or users, consultants and contractors. Another area, I suppose, would be the language used in the form. I'm not saying that the JKR Sarawak form uses convoluted language or very legalistic language, but it always helps to, how do I put it? To use simple English and also more concise wording. So it's easier for the less legalistic minded, if you like, to understand the provisions in the contract. I suppose another area would be ADR mechanisms. At the moment, mediation is already referred to in the contract. There are also, of course, other mechanisms like expert determination, etc., that maybe can be looked into. But I think, as Jocelyn has alluded to before, this, of course, need to be run through or with the Attorney General's office as to the pros and cons and preferences, etc. Lastly, I think one of the things would be integration with digital tools. Again, I think Jocelyn has mentioned there are moves to go in that direction with e-forms, e-signatures, integration with building information modeling. I think, JKR Sarawak has, over the past, I think, was it a couple of years now, as Isabel mentioned, it's now mandatory for projects, building projects over 10 million, infrastructure projects over 100 million to be on the BIM platform. I think we all know that the BIM platform, actually, there's a huge scope in terms of what can be done. It will be a platform that actually assists or enables the digitalization of the whole project, starting from the early design stage to costing, to scheduling, and of course, going on to facilities management, post-construction as well. So I suppose these are some of the things that I can suggest that can be done, to enhance the best practices or the usability of the form going forward.
Okay. Thank you so much, Richard, Jocelyn as well. I think we still have a little bit more time. Maybe we'll just look at the chats and we'll pick probably a couple of questions. The first one that I see is, I think people are actually asking for a copy of the slides shared today. Would that be okay, Jocelyn, for you to share the slides?
Yeah, sure.
And we have a question on who will actually be paying for the fee if there were to be a mediation, like the fee for the mediator. So, Jocelyn?
Mediation actually like some other of the ADR, such as adjudication, actually both the parties will have to come up with the can I say deposit to pair to the maybe AIAC if we are going through that. And so both the parties actually have to share the equal amount of the deposit required by the mediator.
Thank you.
I think that's pretty similar to an arbitration case as well, right? I mean,
Yes,
As well as
arbitration,
adjudication as well, yeah, sure.
And I think if I'm not mistaken, the contract calls for the parties to follow the instructions of the mediator. So it also depends on, what happens after that, what instructions the mediator has to the parties involved.
Right. Okay. I think we still have a little bit more time for a couple more questions. This is a question from Muhammad Ridwan Rasul. Are digital instructions, beam coordination, or online approvals considered valid under PWD 75/2021? Would you like to answer that, Jocelyn? Or
actually, as of now, the version 2021, we do not have any, can I say, like any sort of clauses or elements that consider the digital approval things yet. So that is why we are looking into it now. So hope that in the near future we can come up with certain amendments to include all these digitalizations.
there is also a question from Daniel Sim. Will there be a separate scale of fees specific for BEAM deliverables, or will it be still part of the consultant scale of fees? As of now, it's actually part of the consultant scales of fees, unless there is a revision. I think for BM, they are currently undergoing a revision, which they have tabled to be approved. So I presume BEAM may actually be incorporated as an item inside the scale of fees. But as of now, I think it is considered part of the entire scale of fees. Jocelyn, would you like to take another question, or let's see. This one is interesting, by Ha Tung Ing. How many cases of mediation since we started adopting this GCCC? I think, Jocelyn, perhaps you can answer that.
Actually, we started to use this only 3 years back. As of now, none actually. But using the FOC form last time, yes, there is, I think, 1 or 2 cases where it's instructed by the court actually for the before the litigation start. So as of now, under this GCC, we have yet to have any cases on mediation so far.
Well, we have about a minute left. Do you want to take one more question? Actually, most of the questions are directed to Jocelyn or Richard.
That's fine. Yeah, because everyone wants to know more about the contract.
Right. So I think we have one more here. Says from Muhammad Rizwan Razul as well. Does our project governance comply with the latest anti-corruption audit trail and contract governance clauses embedded in PWD 75, 2021?
Actually, as you can see, I think one of the clauses we have, it's regarding the corruption, clauses regarding corruption as well. But as of now, audit trail, I think it's more on the implementing of the
When you talk about audit trail, it's more administrative, like we have ISO and things like that. Yeah, but like what Jocelyn was saying just then, in terms of anti-corruption, all that, this has already been incorporated into our latest GCC form. Yes. So I think we are there already. So, ladies and gentlemen,
I believe there is some network issue
no
from
form is
surveys.
perfect, no exhaustive, but notwithstanding, JKR Sarawak is committed to the continuous enhancement of the GCC, where we are constantly trying to take cognizance of the opinions of our local industry players and to incorporate any ideas that will bring about synergy and win-win outcomes. Before we end our session, a huge thank you once again to our panelists, Surveyor Richard Fu and Technologies Jocelyn Yeo for their most invaluable insights, as well as to Michelle and Bickham for hosting. With that, thank you very much everyone for joining us. Have a lovely evening ahead. Stay tuned for the latest updates from Bickham. Back to you, Michelle.
Thank you very much, Surveyor Isabel and our panelists for such an insightful discussion. Our next BicTok session will be held on the 5th of November 2025, same time virtually, on the topic of adjudication payment claims under SEPA 2012, the way forward post-ANAS. So do keep an eye out on our social media pages and website for updates on this and for the other subsequent sections as well. We look forward to seeing you then. Thank you once again and have a pleasant evening, everyone.